Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book which has come to us from the publishers Springer. It's a very interesting book. It's got the title Roman Law and the Origins of the Civil Law Tradition. It's been written by George Mousourakis. I hope I've pronounced that name correctly. Now Elizabeth and I have looked at this book and we've given it the title Clear and Accessible Commentary on the Influence of Roman Law on Contemporary Legal Systems. A very interesting and fundamental point. Let's have a look at the book. It's a hardback, and there's the front, there's the side, and then there's the back cover. The book itself has a very useful reference, an index at the back rather. A lot of detail. Then a very select, detailed bibliography. There's a huge amount of learning which has gone into this. You do have footnotes at the bottom of most pages to justify some of the statements made. You also have paragraph numbering, which is actually on the left-hand side with some subheads, which makes life a lot easier. The front of the book, there it is, and then you've got the actual, a nice little dedication there. Then you've got a preface. Well worth reading a preface of this nature. It's an important book, one that affects an awful lot of people, and I think the tradition and the concepts are very important even to us today. And there again is the final part of it, and there's also a useful set of abbreviations, not very many, excuse me, but enough. Then you've got the contents section itself, running through, and it's 8 chapters with the bibliography and index at the back, and then you go into chapter 1 and you can see paragraph numbering and footnotes, and paragraph 2, sources of Roman law. I'm actually quite grateful that I don't have to do Roman law. I did a little bit of it for my LLB many years ago, decades ago, but fortunately it's not on the main syllabus anymore, so we in the common law tradition don't have to do it, but it is interesting to know a little bit about. Obviously it affects Scotland to a certain extent, and of course the European Union. More of that to come. Let me tell you about what we say of this book. For Scottish advocates, as opposed to English barristers or solicitors, Roman law holds less mystery and somewhat more significance than it does for their fellow professionals in England and Wales and other common law jurisdictions. The reasons why are numerous, varied, and often complicated, but certainly understandable and in fact clearly revealed in this brilliant book from Springer Publishing by George Mousourakis, who hails from the University of Auckland in New Zealand. Apart from having to understand a few Latin terms, many of which are fast becoming obsolete thanks to Lord Irving amongst others, most lawyers as well as law students have had little more than a passing acquaintanceship either with Latin or with Roman history. However, on the principle that what has been done in the past invariably impacts on the present, just about anyone interested in law will be interested in this book in our view. It's about as clear a presentation as you're likely to get of how Roman law, directly or indirectly, has spread its influence through the civil law tradition, and to a lesser extent has had some bearing on the development of the common law, which is of course a different type of legal system. And in the words of the author, the book is designed to offer students and general readers an accessible and comprehensive introduction to the subject by combining the perspectives of legal history with those of political, constitutional and social history. Readers are thus given a comprehensive overview not only of the history but the fundamental principles and the major institutions of Roman law. Roman law, says the author, deserves to be studied not merely as an important part of the intellectual background of civil legal systems, but also as an essential part of the history of civilization. He's therefore undertaken a prodigious amount of research at some of the best-known academic institutions for legal study worldwide, including the Max Planck Institute for European Legal History in Frankfurt and the Max Planck Institute for Comparative and Private Law in Hamburg. Succinctly, yet in pertinent detail, he explains how Roman law evolved over a time span of 11 centuries and how it came to be the first catalyst in the evolution of the civil law tradition. This book covers the historical and constitutional context of Roman law and its sources before examining private law. That includes persons, property and succession, plus criminal law, the court system and the criminal justice process. And in the final 3 chapters, the means by which the Roman law system provided the basis for contemporary civil law systems is explained. This section contains commentary on the influence but not the reception of Roman law in Britain, with a brief note on why Roman law is more closely linked to the Scottish legal system than that of England and Wales, bearing in mind Henry II was the creator through Glanville of much of the what we now know as the common law in England and Wales. And of course Scotland was not part of that, part of Britain in that sense at that time. Let me conclude by saying it's worth pointing out that most books on classical history do not often focus specifically on Roman law. This one does, and is therefore a welcome addition to the scholarship on the classical period. It will undoubtedly come to be regarded as an important acquisition for the well-stocked law library, for lawyers and students alike, and the publication date is cited at 2015. I think the important factor is the amount of meticulous research that's gone into this. Here's the book again. It's a hardback, the spine and then the back there. Opening it up again, you can see index, and then you've got this huge amount of information on the select bibliography. He's done a lot of work, and should be praised for it because it's a first-class book without any doubt. Here we go into it again. I said you've got the paragraph numbering at the sides and lots of footnotes to justify points made, and the law of persons, for instance, covered there. You see how the wording is different, and the way I've seen the teaching of law change over the last 2 decades. It indicates to me that we are getting more of a merge in terms of some of the words we're using, so that there's a common type of term that we use, whether it be Roman law based or common law based. We've got a long way to go, but at least there's a start. Then you've got the contents itself again, which I'll just show you there. Not many chapters, I say 8 chapters in total, and then the brief overview right at the beginning. It's an excellent book. I think George Mousourakis has done a brilliant job with this. I'm very pleased with it indeed. Thank you to Springer Publishing for sending it to us for review. It was a very interesting exercise for us. I've learnt a great deal, and I'm sure anybody interested in getting some wider perspective on legal systems will find this a great book. Thank you to all concerned anyway. Bye-bye.